we had, at one point, Mr. McDermott had objected to what he was concerned was going to be a line of questioning by the state regarding this witness's statement as to the results of some sort of DNA. I indicated that for now we were going to stay away from that topic with this witness based on the discussions that we had at the bench. And the reason that we are now revisiting that issue is that Mr. Fawcett approached and asked the court to sort of revisit that ruling, and I felt like we needed to have a more fulsome conversation on the record on that topic so that I could rule. And so that's what we're doing now. Mr. McDermott, you were the one who originally asserted that it would be improper for the expert to for Dr. Terry to make those statements, and you were citing the Williams case, which I found. I think you also cited a Watkins case, which I was not able to locate. I mean, I found, that doesn't mean it, I mean, I just can't find it. I found Disharoon, which obviously where I think Namias is indicating that's an issue that's before the Supreme Court, but.
You said Williams, but the case I cited was Smith v. Arizona.
I apologize. I thought you said the Williams case out of the U.S. Supreme Court and the Watkins case out of the Georgia Supreme Court.
Smith v. Arizona out of the U.S. Supreme Court.
That's after Williams and explains Williams.
Thank you. That's the part I was, well, that shows you why I couldn't find the Watkins case.
Smith v. Arizona 602 U.S. 799.
602 U.S. 799. And what is the?
779.
And what is the Georgia case?
Watkins is 320 Georgia 862.
320 Georgia.
862.
Thank you, sir. If you'll give me just a second to pull that up, and then Mr. Fawcett, I was going to call on you to let me know what the state's position is.
If you read Watkins, you can start at 872. Paragraph head note 16. The middle of that paragraph explains it in two sentences. Yeah, so I'm sorry, 320. Georgia 862. I'm looking at around 872.
So can you give me that site again? Because I thought you said 320 Georgia 860, but that's not.
862.
Thank you.
So Michelle, we've seen maps, but when they have the witnesses point to things where things are found, it's not like putting a dot on the screen for us, or we're not seeing wherever they're displaying it for the jury. So we've seen a map, but it hasn't really been all that helpful. There's been some rough media reporting, I think, because the media reported that the skull was found, it seems to me, in reversed places, going from being found near Brookline versus being found like right on the perimeter, in the road on the perimeter of Action Glass. So I might have a map that Nancy Grace made, but it's incorrect. So let's see. Unless I had it saved to my phone. It might not be on my computer. Yeah, I think I had it on my phone.
Yes.
So yeah, it's been a little frustrating to not always see what they're pointing to when they're talking about an exhibit.
Relying on 24-7703. I think the issue comes down to whether or not the state is intending on introducing documents related to those test results. The experts can rely on evidence, information that is not admitted into evidence, even evidence.
And routinely do, informing their opinions.
That's correct. And so her opinion is based on it's going to be called to determine the cause of death of Ms. Wolfenbarger. And ultimately, she relied on the test results from LabCorp to make that determination as to the cause of death. And that's what her opinion is based on here.
I think maybe part of the reason I'm confused is what exactly is the DNA result that we're talking about here?
So
What?
it's-
Is it confirming that this is Melissa Wolfenbarger or that there's some sort of DNA match to her?
Yes, confirm. Well, the DNA match from well, actually, no, it's the swabbing of Norma Patton and the comparison of that to the extremities that were located on June 1999. Confirming that she was related to Norma Patton.
Okay, and is that in dispute?
I didn't think it was.
I mean, forgive me if I fully acknowledge I might be missing something here, but I was not
DNA
aware that
only
there was
matched
a
to the
dispute that
extremities.
those body parts were in fact Melissa Wolfenbarger's. Maybe there is.
The skull.
Well, first
is
of
in
all, it shouldn't
dispute.
matter whether there's a dispute or not. The rule's the rule. They can't testify to those.
Well, except that I don't have
Second
to
of all-
venture into deciding what the rule is and how it applies in this case if it's not relevant evidence. That's why I'm asking the question. But yes.
There are test results in the back and forth discussion over identifying those remains that in some cases they did not match. So I don't think it is a 100% proven conclusion that all of those remains pertain to Melissa Wolfenbarger.
Oh,
Okay. Well, I guess that demonstrates that I did miss something. There apparently is a dispute that all of those body parts belong to Melissa Wolfenbarger. And again, asking the obvious, Mr. Fawcett, why would whether those body parts belong to Melissa Wolfenbarger or not be evidence of the fact that that her
timing.
manner of death was homicide?
time frame and where she was found.
I guess I'm not understanding the question.
So I don't understand the DA to be offering, I guess the evidence that you're seeking to offer that this witness would testify about is the fact that she understood from the DNA result that those were Melissa Wolfenbarger's body parts.
Correct, yes.
Some of them anyway, according to Mr. McDermott's characterization of whatever that shows. Why does that contribute to the ME's understanding of whether the death was accidental, homicidal, suicidal, or undetermined?
Well, I mean, I think she wouldn't be performing a cause of death determination if the remains weren't first determined to belong to the same person that the skull did. And I think the skull is being compared with the
Look at
extremities.
Hilton.
And that's a part of that too, because you have the same type of cuts and marks on the bones of the skull as you do for the extremities. I think that's a pretty significant fact in that determination of the cause of death being highly likely of being homicide. So I think that, it wouldn't have been a comparison of the extremities with the skull if there hadn't been that information provided by LabCorp to Dr. Terry and Dr. Parker. And ultimately, that's why they made that cause of death determination after all the parts were identified and matched the parts on April 1999, the parts on June 1999. So
He didn't make a cause of death
ultimately, if there's
determination.
an issue as to a specific part, but Dr. Terry can testify as to which part she swabbed and sent off. So if there's a femur versus another femur or an arm that's in dispute, I think that goes to the weight, not admissibility.
Mr. McDermott, can you, I've got Watkins pulled up and I'm still admittedly struggling to locate the portion that you're directing me to.
Okay. If you
One part of the case that we were successful in.
Yeah.
Congratulations, I'd love to read it, but I can't find it.
So that was
So,
their case
first
that
of
they're
all,
citing?
That's the state case. There's also the Supreme Court case that it's Watkins is citing. But if you go to 872,
You said, I think you directed me to a head note and I can navigate it more quickly from there.
so head note 16,
Thank you, sir.
and that'll take you to a paragraph that begins with the word second. Second, the trial court clearly and obviously erred.
I have found it now. Thank you very much.
The beginning of that paragraph says to begin the Sixth Amendment's confrontation clause.
They can't talk to the ME. Or are they not going to call the DNA, the person that did the DNA testing? Because the first ME's dead. And we heard that this might be the last witness, but maybe not. And I've been, it just, it's making more sense now And this isn't good for the state, because the reason it's making sense is because we're like, oh, this is why they're seemingly panicking and trying to ask all these questions about March, April, and, the body parts could have been in the refrigerator to slow the rate of decomposition, right? And yesterday when the Zoom witness lady is blathering on and on about the head cooking inside the bag in the skull that nobody actually knows, because it's stricken from the record. Remember, the jury's not supposed to consider that Detective Kelly got up there and said, well, there was this VHS at one point that showed the dog. Where are you getting this idea that there was a dog carrying the bag with the skull in it? Well, there was the VHS. We never got that VHS. Where is it? I gave it to the prosecution. Who'd you give it to?
Ready? I'd like to add something from Smith v. Arizona that addresses their argument.
That's what I'm looking at now.
Well, Smith addresses Rule 703 and its relation to this analysis. If you go, it's in section 2 under at note 9, but you got to go down to the next paragraph.
Not the dog being rehomed.
Mr. Fossett, have you had a chance to look at the Watkins case or the Arizona case that Mr. McDermott is referring to?
I'm still looking at it, Judge, but we can proceed.
Okay. As I said, when we were at sidebar, Mr. McDermott mentioned the Watkins case, but I couldn't locate it while we were up here. I have now had an opportunity to review it, and it does appear that the Watkins case and the Smith versus Arizona case on which it relies would prohibit that witness from testifying. I understand your effort to distinguish it by saying, well, we're not offering the lab result itself in evidence. And I agree with you that expert witnesses do routinely rely on other people's opinions. But I think that the original ruling I made at sidebar is still the ruling, which is that the DNA test result is hearsay. And there's no one here who can testify to its to the truth of that result, or at least, well, I take that back. There might be, but this witness is not that person.
There we go. And this witness is not going to be the DNA testimony.
All right, Your Honor,
No
I
further
would
questions?
ask for permission to inquire to Dr. Terry whether she collected a sample from Norman Patton, what she did with that sample, and then what she did after the sample return. I don't think that line of questioning, it touches on the results themselves. It just explains her actions and activity, and then what she did after she received information back from that case.
Mr. McDermott?
I think the rule covers that type of questioning. I mean, it's clearly designed to elicit through dancing around the issue of the statement that's being, the truth of the statement that's in the lab results. And I would say that's just as much a confrontation issue.
Okay. So as I understand it, Dr. Terry did in fact conduct a swab herself. She's certainly allowed to testify about something she undertook. She's also allowed to say that she sent it off for testing, because that's something she also did. The extent to which she received a result or anything like that, I agree, invites this sort of cutesy half dodge around the fact that there's not a DNA test result witness currently, and that DNA test result's not in evidence. And so
Get him.
Just in generally speaking, Mr. Fossett, the two questions you mentioned at first, I totally agree. Those are fair game. Those are actions that this person took, and she can testify about them. I think to some extent you could probably ask her what her other steps taken were in her investigation that led to her decision. But what you're going to want to be real cautious about is treading too closely to the line that invites her to say, after doing that to develop an understanding or whatever, because Mr. McDermott's concern is correct that it comes too
strong
close
warning.
to creating an inference that's not supported by any evidence in the trial that there was a positive DNA match.
Yes, sir, I understand.
Mr. McDermott, you can object when he asks the question if you have an objection to the particular question, if you find it objectionable in some manner, other than the record that you've already made. Anything else before we have the jury back in?
Panic, 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 panic. Guys, this is panic. That was a strong warning. This is a cluster. Hilton's going to scramble to find another witness. So judge rules before this witness, Dr. Terry, gets on the stand. She can't testify about the DNA results. She's not going to do it. Fawcett, it seems like he's wrapping up his direct examination. Goes, Your Honor, can I approach? They kick the jury out. They have some stuff to put on the record. It's going to be a longer discussion. We find out he's trying to barge in information about the DNA test results through this witness. And we finally hear on the record for the first time outside the jury's presence that there is a dispute
Okay. Mr.
over
McDermott,
the
anything from the
matching
defense before I
in
have the jury
IDs
back?
No,
for
Your Honor.
multiple
Okay.
parts.
Can I have the witness back, please?
Oh.
Thank you.